Joining us now, MSNBC legal correspondent Lisa Rubin, former FBI general counsel and former senior member of the Mueller probe Andrew Weissmann, and former U.S. attorney and senior FBI official Chuck Rosenberg. All right, I know not everybody is in agreement at this table, and I think that's what makes this a really interesting conversation. I read through the whole opinion myself, and as I said at top, it felt circular in the arguments that the Constitution, the majority argues, implies, it doesn't say so in the Constitution, but they argue it implies that a president has to have immunity to be energetic and to make decisions, that he needs it in order to do the job of the presidency, and that you can't question it, even when he is trying to use that same power to violate the Constitution. As you read through this, as I said, it was hard to look toward the future, and it felt more like an opinion that was squared solely on the present and the present case and the present candidate for the GOP nomination who's running for office against Donald Trump.
So, at the oral argument, there was a lot of discussion about essentially a policy debate that seemed to be going on, where you had the conservative justices saying they're worried about the Department of Justice and prosecutors and grand jurors going after presidents, one after the other, that's the thing that they're worried about. And you had Justice Jackson and others saying, that's not what I'm worried about. We don't have a history of that. What we do have is a former president who's under 4 indictments, who's saying that when he retakes the presidency, he wants to go after people. And you also do have a history of presidents who arguably have abused their powers. Namely, let's just take Richard Nixon. So you do have, on one hand, that's the thing to worry about. And so I think you see that in this opinion, where they're basically saying, no, we're going to, against no historical record, this is what we're going to protect the president from, without really thinking about that you have someone running for office.
It almost seems like they're using, as I said, the Trump case as an academic one, that they're saying that Donald Trump's actions here, it's a good moment for us to be able to define where presidential immunity lies. And they're not treating it, as the special counsel has argued and as Democrats argue, and as a lot of folks saw what happened after the election in 2020, as an existential issue that needs to be addressed.
I would agree with that. And I would also say they seem to be concerned about this unending cycle of prosecution. So, again, I know that Chuck's view of this is that the opinion puts a thumb on the scale not for former President Trump, but for the executive. And there are certainly shades of that. I mean, viewed generously, you can read the section about, for example, the president's interaction with the Justice Department as precluding prosecution, for example, of former President Biden and even the Attorney General for having brought about some of these prosecutions in the first place. And maybe that's good news. On the other hand, it's hard to see how, in considering this moment, they were not more swayed by the existential crisis of the person before us, who is the reason that this case was brought. The reason that we don't have prosecutions in our 234-year history is not because, as John Sauer argued, there was a presumption against prosecuting presidents. It's because we never had elected a person who would have done the things that this president is alleged to have done in the indictment. And the court's failure to grapple with that more transparently, I think, is a failure.
Chuck, push back. What are your thoughts?
Well, look, I don't wholly disagree with anything that Lisa or Andrew said. And by the way, I do think there are some problems with the opinion. Justice Brown Jackson touched on it. There are indeterminate standards that are going to make it hard, not just for the prosecutors, but for the district court judge to figure out what's in and what's out and how they go forward. And, and all of that could be appealed. That said, I do think, as Lisa said, that this has more to do with a thumb on the scale for the executive and less to do with Trump. I take the Supreme Court, and maybe I'm a fool, at their word when they say they're writing for the ages. I know that there is nothing in the Constitution that specifically says a president has immunity, but it is implied. And some level of immunity, both sides agreed at oral argument, was appropriate.
You don't think it really fuzzies up the separation of powers?
Well, that's already pretty well fuzzed up, Katie. Has been for a long time.
So what authority does anybody have over the executive? I mean, this gives him even more immunity. What authority is there to push back on the executive, given this opinion?
Seemingly less.
Or to hold the executive accountable?
Seemingly less and less. I mean, there has been a shift. I think any presidential historian would tell you over the last several decades of authority from the Congress, which has largely abdicated its role to the executive. It's much easier to be a president. You're only one than a member of the legislature, where you're one of 535. That shift is ongoing, and this is a fairly dramatic illustration of it, Katie, but I don't think it's the end of the world. I do think it makes life much more difficult for the prosecutors, because not only do they have to go down to a trial court and figure out, again, what's in and what's out, what's official and what's unofficial, but they're going to lose at least part of their case.
Sonia Sotomayor was, as I mentioned at the top, pretty scathing in her dissent, and she lays out some very disturbing scenarios that she believes would be fine now. She calls Donald Trump's actions treasonous, and then she goes on to say this new Officials Act immunity lies about like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The president of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power, immune. Takes a bribe in exchange for a pardon, immune, 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 immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends, because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. There's never been a moment in history before where this line has needed to be drawn in this way. Presidents have the Office of Legal Counsel. They have lawyers on site advising them where the lines are. Why does the Supreme Court need to get into this?
I think one of the most remarkable things in the majority opinion is they do not address those hypotheticals. So the concern going in was the hypothetical of the Court of Appeals, which was SEAL Team 6. What if the president orders the assassination of his political adversary? And Justice Sotomayor is saying, what about that? Your test, how does it work? The argument is going to be made that that is official conduct. And
I mean, if it's a case-by-case basis, say that happens. Does that then just get litigated? Does it have to go and does there have to be an evidentiary hearing first before it's brought to a full trial? I mean, what is the process by which a person who uses SEAL Team 6 to assassinate a political rival, how are they held accountable?
Can I give you another example, which there won't be a hearing? Is someone whose president says to the attorney general, I want you to bring a bogus prosecution against my political adversary. So not death, just prosecution. This decision says communications between the president and the attorney general are absolutely immune.
You can't even bring them up as evidence.
They're absolutely immune, and you can't even use it as evidence. Yes.
There's no discussion about whether that's official or unofficial. The court takes that fully off the table. They say it's a core constitutional function that control over investigations and prosecutions fall into the core executive powers of the president, for which we don't even get into the land of evidentiary hearings. And as Andrew says, that's a very frightening prospect that any president can use. Forget about SEAL Team 6. Having the Department of Justice at your disposal to use their favorite word, weaponize it, is an extraordinary thing under this opinion.
There is still the case that Jack Smith has. It does still exist. It will go back to Judge Chutkan. The conversations that Donald Trump had with his Department of Justice seem to be off the table now, but there is a question about conversations he had with Mike Pence. Those are presumptively immune, but it's up for debate. And then there are the fake set of electors, et cetera. So if you are Jack Smith and you read this today, what are you seizing on?
Well, I'm not having a great day if I'm Jack Smith and I'm reading this right now, but I think there are glimmers of hope, or at least things he can grab onto and argue. For instance, in the January 6th indictment, Katie, there are allegations that Mr. Trump consulted with private lawyers and private consultants, people outside of the executive branch, outside of government, to perpetuate his fraud. I would argue that that is not immunized and wholly within the ambit of the prosecutors. to your point about conversations with Mike Pence, presumptively off limits, but that presumption is rebuttable. And that's what, and that's hard. I don't mean to suggest it's easy or they're going to prevail, but I think the prosecutors have arguments below, and the devil's in the details. And I hate that cliche, and I've used it 17 times today, but it is. And so we have to see what Judge Chutkan does with this and whether she can figure out the indeterminate standards that Justice Ketanji Brown Jackson warned of. There's chapters to be written. One problem, though, Katie, is that these chapters aren't going to be written for quite some time. And if Mr. Trump becomes president, perhaps not at all.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.